Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here at County Court at Law Number 2. You have been asked to come to court today for what we call an arraignment. And what the arraignment is just an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case. Criminal cases are divided into felonies and misdemeanors. Your felony cases are normally referred to as your more serious type offenses, whereas your misdemeanor cases are normally referred to as your petty offenses. It does not mean that they're not serious. It just means that they are not as serious as a felony case. Now, when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can get if they are convicted of the offense. Now, felony cases are divided into 5 categories. We'll start at the top and work our way on down to the bottom. You have the capital murder, first degree felony, second degree felony, third degree felony, and the state jail felony. If a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail and a fine that does not exceed $10,000. If a person is convicted of a third degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a second degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a first degree felony, the range of punishment is minimum 5 years to a maximum of 99 years or life in the state penitentiary, or a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a capital murder, the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, you don't have to worry about those type of punishment because, as I mentioned to you earlier, your case is a misdemeanor case. Now, misdemeanors are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. If a person is convicted of a Class C misdemeanor, the conviction starts in the JP court or the city court. For example, a Class C misdemeanor will be speeding, driving without your license, not having your seatbelt on, not having an inspection sticker. All of those type offenses are considered Class C offenses. And as I mentioned to you earlier, they start in the JP court or the city court. They come to this court when a person is convicted and they file what we call an appeal. In essence, they get a whole new trial in this court. Now, the punishment range does not change. Now, the punishment for a Class C misdemeanor is by fine only. You cannot be given sentenced to jail time. It's by fine only, and the fine cannot be above or cannot exceed $500. Now, if a person failed to pay the fine, or if the fine was converted to community service and they failed to perform the community service, then the court can issue what is called a capious profile. What that means is it's a warrant for the rest of the person to either pay the fine or for them to sit the fine out in jail. Now, if they sit the fine out in jail, they'll credit it at $100 per day for every day that they sit in jail. All right. Now, the next highest misdemeanor is a Class B misdemeanor. With the Class B misdemeanor, the range of punishment is minimum 0 days to a maximum of 180 days in the county jail or you could be given a fine that does not exceed $2,000, or you could be given both such jail time and a fine. The next highest, or the highest misdemeanor, is a Class A misdemeanor. But the Class A misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days, which is a year, in the county jail, or you could be given a fine that does not exceed $4,000, or you could be given both such fine and confinement. Now, you may be eligible for probation. There are two types of probation. One type of probation is called unadjudicated probation. Unadjudicated probation, what that basically means is that you will not have a conviction on your record. And if you successfully complete the probation, you won't have a conviction on your record, and the case will be dismissed, and you may qualify for what is called a non-disclosure. What a non-disclosure is basically your record is sealed to the general public. So the general public cannot see your offense that you receive unadjudicated probation on. Now, most of the public is the general public. Now, the operative word is general public because certain governmental agencies like the police department and the agencies that are listed in the Texas Code of Criminal Procedure can have access, but most of the public is the general public, so they cannot have any access. For example, you applied to a job at ExxonMobil. You had deferred adjudication, you completed it, you got a non-disclosure, ExxonMobil do a criminal background check on you, that case that you received deferred adjudication on will not come up. Why? Because your record is sealed to the general public. Okay. Now, the next type of probation is called adjudicated probation. We had unadjudicated probation. Now, the next type is called adjudicated probation. With the adjudicated probation, we normally refer to it as regular probation. You do have a conviction on your record. However, there is something that is called judicial clemency. Judicial clemency means that the court or the judge can set your conviction aside. You won't have no conviction. Okay? Now, in order to qualify for judicial clemency, 3 things has to happen. 1, you have to complete the probation. 2, there cannot be any more time left on the probation. And 3, the probation office has to discharge you off or let you off the probation. If those 3 things happen, then the court or the judge has the discretion to set your conviction aside, so you will no longer have this conviction. Now, if you get a subsequent conviction, but that basically means if you get another conviction later on, then the case that you receive judicial clemency on can be brought back up. It could be brought back up, it could be resurrected or revived. And if you try to get a license with Child Protective Services, they could deny giving you a license, or if you have a license, they can revoke or suspend your license. Okay. Now, everyone that's here for arraignment should have a clipboard. Who does not have a clipboard? If you're here for arraignment, you have, okay, this gentleman needs a clipboard. And I'm getting ready to go over that information on the clipboard with you.
No, that's good. It's okay, Ms. Lord.
Okay. Now, that first page, the first long page, not the little short page, the first page. And that page should look like this. The page is titled Judge's Explanation of Rights to Defendants Without Attorney. This document states, and we're going to continue constantly referring back to this document. This document states that as a defendant in a criminal case, you have 3 options regarding your right to have an attorney. Number 1, you may hire an attorney. Number two, you may request that an attorney be appointed to represent you. And number three, you may represent yourself. Now, the first sentence under number three states that if you want an attorney and you have enough money to hire an attorney, your case will be reset. Reset means that you'll be given another court date and to give you time to hire your lawyer. Okay? Now, for those individuals who will be hiring their own attorney, this is the only document you would have to sign. Okay? Now, the second sentence under number three states that if you want an attorney, but you do not have enough money to hire an attorney, then you may request that an attorney be appointed to represent you. But you must first fill out a financial questionnaire so that the proper person can determine whether or not you qualify for a court-appointed attorney. Now, the financial questionnaire is also on the clipboard. It is a 3-page document that is titled Jefferson County Affidavit of Indigence or Affidavit of Indigence. Now, only individuals who will be applying for a court-appointed attorney needs to fill this out. If you are not applying for a court-appointed attorney, you don't need to worry about this form. Okay? Just those individuals who will be applying for a court-appointed attorney. Now, those individuals who will be applying for a court-appointed attorney, you would have to fill out the first page of this document. And then you'll go to the second page. The second page at the top should say Defendant's Oath. You will fill out the top portion. It should have a little bracket that says Defendant's Oath. And then you go down to the middle portion where it says Unsworn Declaration by Defendant. You'll fill that out and then you'll stop. You won't have to fill out anything else. All right. Now, going back to the first document. The third sentence under number 3 is for people who will be representing themselves. So if you're not representing yourself, you don't have to worry about this. That is, if you want to hire an attorney, you don't have to worry about this. If you want to apply for a court-appointed attorney, you don't have to worry about this. But for those people who will be representing themselves, this paragraph states that you may not talk to the prosecutor about your case unless you first fill out a waiver of counsel. Okay, what that means is this. If you represent yourself, you are your own lawyer. Just like the lawyer can talk to the prosecutor is assistant criminal district attorney. Just like the lawyer can talk to them about your case, because you are representing yourself, you are your own lawyer, you can talk to them about your case. Okay? But before you are able to do that, you have to fill out a waiver of counsel. Now, the waiver of counsel is another document on that clipboard. Now, this is only for people who will be representing themselves. You would have to fill out this document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. You will read this document, sign where it says defendant, and date it, and then stop. All right. Now, going back to this first document, there's a paragraph. It's the second to the last paragraph. It states, and this is for people who will be representing themselves. So if you're not representing yourself, you don't have to worry about this. It states, be aware that there are dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens and employment. Now, the last one sentence paragraph is for those individuals who represent themselves. It says that if you are representing yourself, you may change your mind at any time and ask for an attorney to be appointed to represent you. So, for example, let's say you're representing yourself, and let's say you have in mind that you want to get probation on the case. And let's say you talk to the prosecutor, and the prosecutor said, well, we're not offering probation on the case, we're gonna offer you a fine, or we're gonna offer you jail time. Well, you say, well, I don't want that. And then you say, well, judge, I want to apply for court appointed attorney. I changed my mind. And I don't want to represent myself. You can do that. Okay? Now, at the bottom of this document in bold print, it states defendant's choice. Mark initials next to only one choice. Now, everybody's going to make a choice on one of these 5 lines down here to the left. Okay, if you would like to hire your own attorney, then you will place your initials on the first line to the left. Put your initials on the first line to the left, sign it and date it, and then you'll stop. This is the only form you have to sign. If you have already hired an attorney, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. Then you'll sign at the bottom, date it, and then you'll stop. This is the only form that you would have to sign. If you are applying for a court-appointed attorney, then you'll place your initials on the third line to the left. You will sign the bottom of this document, and then you will date it, and then you will fill out this document that is titled, this 3-page document that is titled Affidavit of Indigence or Jefferson County Affidavit of Indigence. And as I mentioned to you earlier, you'll fill out the first page, and then you'll go to the second page, fill out the top portion that's titled Defendant's Oath, and then the middle portion that's titled Unsworn Declaration by Defendant, and then you'll stop. Okay, now going back to the first document. If you already have been appointed a court-appointed attorney in your case, then you'll put your initials on the fourth line at the bottom to the left. Then you will sign and date it, and this is the only form that you would have to sign. Now, for those individuals who will be applying for a court-appointed attorney, you'll put your initials on the last line to the left, which is the 5th line. And then you will sign where it says defendant, and you put the day's date, and then you'll stop. The day's date is February 10th. And then you will fill out this last form. This is for only individuals who will be applying, who will be representing themselves. Then you fill out this form that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. Okay, do we have any questions? Okay. Okay, now we're going to give you time to fill out that paperwork. So you don't have to do it right now. I mentioned to you that we're going to tell you about your rights and your options and what you've been charged with. Now, you have a right. Well, first of all, you could enter one of 3 types of pleas, and I'll explain that to you. You could enter a plea of not guilty. If you enter a plea of not guilty, you're telling the court that you did not commit the offense that you have been charged with. Or you can enter a plea of guilty. If you enter a plea of guilty, then you're telling the court that you committed the offense that you have been charged with. Or you can enter a plea of no contest. If you enter a plea of no contest, you're telling the court that you will not be fighting or you will not be contesting the charges. All right? Now, you have a right to have a trial by jury. For those young people that are sitting in that area, we call that the jury box. 6 citizens from Jefferson County will be selected to serve as jurors in your case. And what they will do is they will listen to all the evidence that's presented by the state and by the defense. They will listen to the arguments of the state and the defense. They will go back into the jury room to deliberate, and they will come out and they can find you either not guilty or guilty of those charges. You can waive or give up your right to have a trial by jury. And what that basically means, if you waive or give up your right to have a trial by jury, you will not be having a trial by jury. However, you still can have a trial. You can have what is called a bench trial. That is a trial by judge, where the judge will be the judge and the jury. The reason why they call it a bench trial is because the judge sits on the bench. So they call it a bench trial. Now, you can waive that as well. If you want to enter guilty no contest, and you want to see whether or not you can work out a plea bargain agreement to settle your case with the state, you can do that as well. Now, you could, there are 2 types of plea bargain agreements. One is called an agreed plea bargain, and the other is called an unagreed plea bargain. And I'll explain that to you. If you're in the state, or your attorney and the state have talked and y'all worked out an agreement to settle your case, we call that an agreed plea bargain. Once you get an agreed plea bargain, it has to come before the judge. The judge can do 1 of 2 things. The judge can accept or reject the plea bargain agreement. Now, if the judge rejects your plea bargain agreement, guess what? You can take your plea back. You don't have to go forward with the plea. If you came to an agreement with the state and the judge says, well, I'm not going to go along with that, I reject it, then you have a right to take back or withdraw your plea. Now, if the judge does go along with the plea bargain agreement, and let's say within 30 days, you'd like to appeal your case, or you'd like to have a new trial, the judge has to give you permission to appeal your case. If the judge who followed the plea bargain agreement, now if the judge gives you permission to appeal your case, then your case will leave this court and go right upstairs to the Ninth Court of Appeals. There are 4 judges up there, they're justices, they will review your case. They can either grant or deny your appeal. If they grant your appeal, they can just simply find you not guilty, case over. Or they can send the case back down to this court and order this court to give you a whole new trial. Now, if they reject your appeal or if they deny your appeal, guess what? You can appeal it to a higher court than the Ninth Court of Appeals. You can appeal your case to the highest criminal court in the state of Texas, which is the Texas Court of Criminal Appeal. They're located in Austin, Texas. Now, you would have to file what is called a pro se petition for discretionary review. I'll explain that to you. Pro se means self. That means you're representing yourself and you're petitioning or you're asking the Texas Court of Criminal Appeals to review your case to see whether or not your appeal should have been granted or whether or not this court wrongfully convicted you or committed an error by convicting you. They can do 1 or 2 things. They can grant or deny your petition. If they grant your petition, they can simply find you not guilty, case over. Or they can send the case back to the Ninth Court with orders, or they can send it back down here with orders. Now, if they deny your petition, then at that point, your conviction will stand. Now, as I mentioned to you earlier, besides having an agreed plea bargain agreement, you can have an unagreed plea bargain agreement. What that means is you talk to the state, you don't like what they offering, you want a probation, they offer jail time or a fine. So you still want to plead guilty or no contest, but you want the judge to decide. We call that an unagreed plea bargain. And the judge will assess punishment within the punishment range, anywhere within that punishment range. All right. Now, you also have a right to have witnesses to come to court. Witnesses sit in that chair that has the microphone in front of it. We call that the witness stand. Witnesses can testify for you or against you. If you're representing yourself, you can ask some questions. or if you have a lawyer, your lawyer can ask some questions. We call that either direct examination or cross-examination. Now, you also have a right to waive or give up your right to have witnesses. In essence, you don't have to call witnesses. What that means is if you don't call witnesses, it does not mean that the state will not be calling witnesses, because they will be calling witnesses in your case. Now, you also have what is called a Fifth Amendment right against self-incrimination. That is, you have a right not to testify in your case. The state, the government, the DA's office cannot call you to the witness stand. They cannot force you to testify against yourself. And if you think about it, it makes sense. Why does it make sense? Because the state has the burden to prove you guilty beyond a reasonable doubt. You don't have to prove yourself guilty. Okay? That's their job. That's not your job. And so, if you exercise your Fifth Amendment right against self-incrimination, you have a right not to testify. Now, you can waive it or give it up. If you waive it or give it up, that simply means that you will be testifying. Okay. Now, you also, the last thing I want to talk about is your the right to have discovery. And what discovery is, you have the right to have access to the state's file. What that means is this: you have a right to see the evidence that the state has against you. Okay? You have a right to see your statements, witness statements, police reports, lab reports. You have a right to see video recordings, listen to audio recordings, see photos, see documents, any instruments that they may have. You have a right to have access to that. That's called discovery. Now, you can waive or give up your right to have discovery. If you do that, that means that you will not be having access to it. Okay. Now, everyone that's here today, you've been, with charges been filed on you, you've been arrested, placed in jail, you bonded out of jail, you're out of jail either on a cash bond, which means you paid the full amount of bond to get out of jail. You're out of jail on a surety bond, which means you have to pay a bondman a percentage of the bond to get out of jail, or you're out of jail on a PR bond or a personal recognizance bond, which means that you did not have to pay any money to get out of jail. You was released under your own personal recognizance. Now, I said that to say this. Every day that you spent in jail can be used as credit towards your punishment. So, for example, let's say you spent 5 days in jail, and let's say the state, you talk to the state, or your lawyer talk to the state, they offer you 5 days in jail. And what that means is you won't have to spend no more time in jail because you've already spent 5 days in jail. Therefore, you'll be given credit for the time that you have already served. Now, if the state is offering 7 days in jail and you spend 5 days in jail, that means you will only have to do 2 days because you've already served 5. You would subtract 5 from the 7, that leaves 2. Now, every day that you spent in jail can also be used as credit toward your fine and court costs. Every day that you spent in jail, you are given $100 credit toward your fine and court costs. So, for example, in our scenario, if you spent 5 days in jail, that's $500 that's credited toward your fine and court costs. So, if the state is offering you fine and court costs of $500, that means you don't have to pay anything. Why? Because the time that you have spent in jail has already paid it off. Okay? Now, if the state is offering fine and court costs of $700, that simply means that you would have to pay $200. Why? Because you already had $500 paid. If we take $500 from the $700, leave $200. You'll be required to pay it on the day that your case is disposed of. Now, if you cannot pay it, no problem. Because we could put you on a payment plan where you could pay it off in small monthly installments until it's paid off. Now, if you do not have the income to pay off the payment plan, no problem. Because we can convert your fine and court cost to community service. And so for every 1 hour of community service that you perform, you will be given $12.50 credit toward your fine and court costs. So for example, if you work 8 hours one day, that's $100. That's towards your finding court costs. So in our scenario, you owe $200, you work 2 8-hour days, that's $200, and guess what? Your finding court costs is paid off. And then you're through with it. Now, for those individuals who, if you haven't been in trouble before, you never had any cases filed on you, now you have one or more cases. Well, Jefferson County District Attorney's Office has a program that is called pretrial diversion. And what that program means is this: they will dismiss your case on cases. And if you successfully complete the program, you can get an expunction. An expunction means where it's erased, deleted, wiped off of your criminal record like it never happened. Okay? In order to qualify for the program, 3 things. 1, it cannot be for an offense involving unlawful carrying a weapon or resisting arrest. 2, you have to have an attorney to assist you to get into the program with the application process. The attorney could be a court-appointed attorney. Don't have to be somebody you hire. And then 3, it has to be your first time basically getting in trouble with the law. Those 3 things happen, you qualify, you get into the program, they dismiss the case, you complete the program, you get it wiped off your record. Okay. If they have another program, the District Attorney's Office has another program for veterans only. If you're a veteran of any one of the branches of the United States military forces, with the Veterans Court, you get into the program, you complete the program, they will dismiss the case. And you can get what is called, as I mentioned to you, a non-disclosure where your record is sealed to the general public. The only requirement to get in that program is to be a veteran of any one of the branches of the United States military. That's it. Okay, now this court, County Court and Law Number 2 of Jefferson County, Texas, has a program that God led me to start in the first 100 days of me taking office, which was in March of 2017. The program is called the CSI program. CSI is an acronym that stands for Community Safety Initiative. The program is designed to address the issue of what we call recidivism. I'll explain that to you. Recidivism means when people commit crimes over and over and over. Okay. And so with the program, we have partnerships with various agencies in our Jefferson County community. One of the agencies that we have a partnership with is Spindletop Center. Spindletop Center is our local mental health center in the Southeast Texas region. Now we have some individuals from Spindletop. They'll come to you in a few minutes and tell you a little bit more about the program. But basically, what Spindletop will do, Spindletop will have a private interview, either in our jury room, in their facilities, or by telephone, whichever is convenient with you. They can do an assessment. An assessment is to determine what your mental health issue is. And they can develop a treatment plan to address your mental health issue. Now, you do not have to be incompetent or insane to participate in the program. You can simply suffer from anxiety or depression or any other host of mental illnesses, and they have the expertise to address your mental health issues. Now, Spindletop also have a drug and recovery program that's called ATAR. ATAR is an acronym ATAR that stands for Addiction, Treatment, and Recovery. We also have a partnership with our local drug and alcohol council that has a program that is called OSAR. OSAR, OSAR, is an acronym that stands for Outreach, Screening, Assessment, and Referral. Both of those programs are drug and alcohol recovery programs. Now, if you have issues with drugs and alcohol, well, they have the ability to address your problem. And what they will do a screening, and then They will do an assessment to determine what your drug and alcohol issue is. And then they can develop a treatment plan either for outpatient or inpatient treatment as well. If you are unemployed, or maybe you're simply looking for a better job, well, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. And Lamar University has a program that is called CICE. It's an acronym that stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you are trained in any one of those areas, they will help you to get a job in the area that you're trained in. Now, if you have not graduated from high school, if you do not have a GED, well, they also have a GED program where you can get your graduate equivalency diploma. Now, all of these programs that I just mentioned to you are free. Does not cost you anything but time. And I like to say in this course, we don't just give time. We take our time. And that is, we don't just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I like to say that when you come to County Court at Law Number 2 in Jefferson County, Texas, we do not just have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we'll make a difference in their home. And if we make a difference in their home, we'll make a difference in the community, because what comes out of the home goes into the community. So if you're interested in any one of these programs that I just mentioned to you, just let us know, and we can direct you to the people that you need to talk to so that you can get on the road to living your best life. So at this time, as I mentioned to you earlier, we have some folks from Spindletop. They're going to tell you a little bit about the program that Spindletop has. We have our mental health deputy Butler, and we have Tom.
Thank you, Judge.
You're welcome.
Good morning, everybody. Deputy Butler with the Jefferson County Sheriff Department. Here to assist the Spindletop program. My part in assisting with that program, not to counsel with you, but to assist you with some transportation if you so become a Spindletop client. You need transportation to make your appointments, doctor's appointments, or pick up medication, or to be transported to a job, whatever. That's what our part is for. Ms. LaTanya here, she's the qualified mental health professional. She can tell you more about the Spindletop program, what's all involved in it.
Good morning, you guys. Good morning. This little form here, it is probably in the back of the clipboard or in the front of the clipboard. It's totally optional. You guys didn't have to fill it out. But if you would like to receive the services, fill that form out. We'll actually pick them up in a few moments, but as Judge Holmes was stating, we offer substance abuse, we offer counseling, and the said transportation. If you guys need any services and we have it available, we can talk to you guys one-on-one today. You can leave a phone number. I text. I know most people don't answer the phone even, but I text or call, even email. So if you guys want to receive any services, just go ahead, fill out the form. Behave. Fill out the form and we can speak with you guys today, like I said. But as the Judge Holmes stated, substance abuse, mental, or even just health loss. Okay. Any questions?
Also remember that whatever information you share with the qualified mental health professional, it's kept private under the HIPAA law. Not allowed to get an information out to anybody. It's kept private between you and them.
Okay. Thank you. Okay, ladies and gentlemen, now the paperwork that you, filled out, we're going to pick that paperwork up for you. And we're gonna put you in one of three groups. One, if you like to hire your own attorney, then, again, what will happen, you'll come up, your case will be reset. Reset means you're gonna be given another court date, give you time to hire your own attorney. And then you will get that reset, you'll be free to go. Second group is if you would like to apply for court-appointed attorney. If you, meet the qualifications for a court-appointed attorney, then your attorney will be appointed to you today before you leave. Okay? And the third group, if you would like to represent yourself, you will have an opportunity to talk to the prosecutor, and if you come up with a plea bargain agreement that you like, your case will be taken care of today. Okay? Now, it's gonna take us a little time to finish picking up the paperwork. And, once we finish picking up the paperwork, then we're gonna call you to the bench one at a time, go over the paperwork, make sure that you understood what you read and what you signed. And then you, go on, from here. Now, you have a question?
I was trying to see, even though you don't know what you want, you just can type the first thing.
As long as you, say, you wanna represent yourself. Cause as I mentioned to you earlier, in that document, you can always change your mind. If you represent yourself, you can change your mind and ask for an attorney to be appointed to represent you. But you must first, if you gotta talk to you, you fill out the form saying that I wanna represent myself, waive my right to attorney, and then you have an opportunity to talk to the prosecutor. Okay, now if you don't, as I mentioned to you earlier, you can always change your mind. Yes,
Thank you, Judge. I have a question. My guy gonna represent himself. Am I allowed to help him in any way, or is it just?
no, you're not his attorney.
So,
No, if that's what he wants to do, he can make that decision, and then he'll have an opportunity to talk to the prosecutor.
yes,
Okay,
okay.
oh, yes.
You have to speed trials,
Hmm?
speedy trials, you have to speed trials.
You have to file, if you're representing yourself, you have to file a motion for a speedy trial. Okay. That's a right that's given to you, but anything that comes before the court, it has to come before, but not by request, it has to come before the court by way of what we call a motion.
Okay.
Okay, anybody else? Anybody else had their hands up? Okay, now, if you need help with that paperwork, we have our court personnel who's here. They're gonna come out, including myself. We'll be happy to help you with the paperwork so that it is filled out properly. Yes, you had your hand up?
Could you get a point lawyer, you will, have to get another court date or?
Oh, yeah, because the lawyer's not here right now.
Okay.
Yeah,
I
because,
got another question. Like, I'm not from the state, so can I like get virtual?
virtual,
Like, you know, you can talk to them on the internet?
well, that's between you and your lawyer.
Okay, okay,
Yeah, I don't know,
okay.
you know, what your lawyer can do. Yeah, anybody else? Okay. Okay, now, it's gonna take us a little time to pick up the paperwork. Once we pick up the paperwork, again, we're gonna call you one at a time now. If you need to use the restroom, there are two restrooms right out in the hallway. The men's restroom is in front of County Court at Long Tree, which is right next door. The women's restroom is on the opposite side of the hall, in front of the 172nd District Court. You will be allowed to use the court, to use the restroom. Please do not leave the courthouse. If you leave the courthouse and your name is called, and you're not here, your bond is gonna be forfeited and a warrant is gonna be issued for your arrest. And guess what? We're gonna have to go through this all over again. All right, you'll be arrested, go back to jail, and then you gotta bond out, and then go through the same process. All right, yes, ma'am.
I love your phone, but baby, I don't want to restart.
All right, so be mindful, we're still in court,
Yes,
so conduct yourself accordingly. Oh, I forgot to mention that at the top of that document, it just has the state of Texas versus, and it's a line. Print your name on that line.
Yes, sir.
Because if you, sometimes people write the signature, you can't read it. But if you print it, we can read it. And anybody need help, just raise your hand. If you have a case involving family violence, there's a program that is called BIP, Violence Intervention and Prevention Program. With that program, go through the program and completely your case will get dismissed. And you can get a response from the record. Okay? Now, that's for individuals who have cases involving family violence. And we have Mr. Johnny Stewart, who's here from Family Services. We can tell you a little bit more about that program.
Okay, thank you, Judge.
You are.
Good morning, everyone. I'm Johnny Stewart. I'm with the BIP program. It's the Batteries Intervention and Prevention Program with Family Services. What we do is we provide a program for men and women who first time domestic violence charge. And it's an 18-week program. It's a 2-hour group. We have Zoom and we also have in-person groups. So once you complete that program, then these charges can be dismissed. So we encourage you not only to take them because you want the charges, because you want to change those behavior. And so we encourage you to participate in that program. It's a good program on over several years now. So if you have any questions, you give them the ABA and he'll explain more to you. Thank you very much. Thank you.
All right, thank you, Mr. Stewart.
Yeah. Let's go that one out. Oh, goodness. Mm, meeting.
Ms. Hargrave?
Yes, sir.
Okay.
Yes, sir.
Your case is gonna be reset so you could be here in person?
Yes, sir.
Okay,
I don't have a vehicle at the moment and, so I have to get a ride, but I'll do the best I can because this is serious. Go ahead.
okay, give us a reset date.
Um,
What is it? Okay, Ms. Hargrave, your case is gonna be reset to February 24th at 9 a.m. and you need to be here in person. Stay in
Okay,
contact
yes,
with
sir.
your bondsman because your bondsman will be giving you a court date. That's
Okay,
say that again, February the 24th at 9 a.m. County Court at Law number 2, Jefferson County, Texas.
okay, that's your court,
Yes,
correct?
right.
Yes, sir.
Okay,
I'll be
you're free
there.
all right, you're free to go and you have a blessed day.
All right, thank you. Bye-bye.
Welcome.
Where the motherfucker is at? Who knows?
Jefferson County Court at Law number 2 is back in session. Court is in session with the arraignment docket. When I call your name, please come before the bench by yourself. First case is cause number 25 CCCR 2774. Case is styled the state of Texas versus Joseph Martin. Martin, would you please come forward? Mr. Martin, your full name is Joseph Ryan Martin.
Yes, sir.
Mr. Martin, would you please raise your right hand? Swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Mr. Martin, you may put your hand down. How are you doing, Mr. Martin?
Doing good today.
That's good. Mr. Martin, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir, I do.
Is this your signature on the line
That
that's
is
titled
my
defendant? And are these your initials on the line that state you would like to have your case reset
Yes, sir, they
to
are.
hire your own attorney?
Yes, sir, they are.
Mr. Martin, before you signed this document, did you read the document?
Yes, sir, I did.
Did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, it is.
Okay, Mr. Martin, your case will be reset by our court coordinator. Once she gives you your reset, you're free to go,
Sir.
and you have a blessed day. Please stand in front of the court
Thank you,
coordinator.
Judge. Bless you.
Thank you. Same to you. Ronald Benoit. Mr. Benoit, your full name is Ronald Dale Benoit.
So,
Mr. Benoit, would you please raise your right hand? Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth, so help you God?
yes, sir.
Mr. Benoit, you may put your hand down. How are you doing, Mr. Benoit?
Doing all right.
That's good. Mr. Benoit, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled defendant? And are these your initials on the line that state you'd like to have your case reset to hire your own attorney? Mr. Benoit, before you signed and initialed this document, did you read the document?
Yes, sir.
Did you understand what you read? And is everything in this document true and correct to the best of your knowledge? Okay, Mr. Benoit, I read your answers. Based on your answers, your case will be reset to give you an opportunity to hire your own attorney. Our court coordinator is going to give you that reset. Once she gives you that reset, you'll be free to go, and you have a blessed day. Please stand in front of the court coordinator. Brittany Howyer. Ms. Howyer, your full name is Brittany Howyer. Ms. Howyer, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Howyer, you may put your hand down. How are you doing, Ms. Howyer? I'm doing fine. Thanks for asking, Ms. Howyer. I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled defendant? And are these your initials on the line that state you'd like to apply for a court-appointed attorney? Also, I have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is that your signature? Now, Ms. Howyer, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Ms. Howyer, I read your answers. Based on your answers, you meet the eligibility requirement for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you is Attorney Jennifer DeLodge. Attorney DeLodge will be given information to contact you, and you will be given information to contact her. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day.
Michael Fulton?
Miracle Smith. Ms. Smith, your full name is Miracle Smith? Ms. Smith, would you please raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, Ms. Smith, you may put your hand down. How are you doing, Ms. Smith?
Fine.
That's good. Now, Ms. Smith, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Turning. Do you recognize this document?
Mhm.
And is this your signature on the line that's titled Defendant? Are these your initials on the line that state you would like to apply for a court-appointed attorney? Also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature? Now, Ms. Smith, before you signed and initialed these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, now, Ms. Smith, I read your answers. Based on your answers, meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Mark Faggart. Attorney Faggart will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Now, before she gives you that information, the bailiff is going to hand you a document that is titled Standard Bond Conditions in County Court at Law Number 2. I'm going to go over this document with you, and it states following return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas. All bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Mhm.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition? And condition number 3 states that the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition? Okay, now condition number 4 does not apply. However, condition number 5 does apply. And condition number 5 states defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 the Texas Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition? Now, Ms. Smith, if you violate any one of these conditions, your bond will be revoked, and if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand? Okay. Please stand in front of the court coordinator. She's going to give you a reset. Once you get your reset, you're free to go and you have a blessed day.
Okay.
You're welcome. Here you go. Freddie's in. This is cause number 25 CCCR 0764. Case of South State of Texas versus Freddie Cornelius Zinn III. Mr. Zinn, is that your full name?
Yes, Your Honor.
Mr. Zinn, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Mr. Zinn, you may put your hand down. How are you doing, Mr. Zinn?
I'm fine, and yourself?
I'm doing fine, thanks for asking. Now, Mr. Zinn, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, Your Honor.
Is this your signature on the line that's titled Defendant?
Yes, Your Honor.
And are these your initials on the line that state you would like to apply for a court-appointed attorney?
Yes, Your Honor.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, Your Honor.
On page 2 of this same document, there's a signature above the line that is titled Defend the Signature. Is this your signature?
Yes, Your Honor.
Now, Mr. Zen, before you sign and initial all of these documents that I've just showed you, did you read the documents?
Yes, Your Honor.
Did you understand what you read?
Yes, Your Honor.
And is everything in these documents true and correct
Yes,
to the best of your knowledge?
yes, Your Honor.
Mr. Zen, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney David Grove. Attorney Grove will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go. And you have a blessed day. Please have a seat in that second chair on the wall.
Yes, sir. You too.
Thank you.
Thank you.
Lawrence Richard III. Oh, they got third on here.
Actually, I'm a junior judge.
Hmm?
I'm a junior.
Junior, okay. Now, Mr. Richard, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
No.
You may put your hand down now. I know we're in Texas. Do you pronounce Richard or from Louisiana is Richard?
Richard.
Richard, okay.
Bennett, last name.
Oh,
Richard.
well, okay.
Richard.
Okay, you from Texas. Okay. You cross the Sabine River, you're gonna be in Louisiana.
Then you go Richard.
The Richard.
How we get an E out of an I?
It's French,
Yeah.
like Hebrew.
Mm-hmm.
It's a bear.
Mhm.
French.
Exactly.
Okay, now, Mr. Richard, I have before me, but do I swear you in? You swear to tell the truth, the whole truth, and nothing but the truth? Okay, now, Mr. Richard, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Sure.
Is this your signature on the line that's titled Defendant? Or are these your initials on the line that state you'd like to apply for a court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? And on page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yeah.
Now, Mr. Richard, before you sign and initial these documents, did you read the document? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Now, Mr. Richard, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Jack Lawrence. Attorney Lawrence will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in that second chair on the wall. Thank you. You are Travis Gilkey. Mr. Gilkey, your full name is Travis LaShawn Gilkey. Mr. Gilkey, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? Okay, Mr. Gilkey, you may put your hand down. How are you doing, Mr. Gilkey?
Okay.
That's good. Now, Mr. Gilkey, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant? Or are these your initials on the line that state you like to apply for a court-appointed attorney? Also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of this same document, there's a signature above the line that is titled Defendant Signatures. This is your signature. Now, Mr. Gilkey, before you sign and initial these two documents, Did you read the documents?
Yes, sir.
Do you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Correct.
Okay, Mr. Gilkey, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Todd LeBlanc. Attorney LeBlanc will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once you get that information, you'll be free to go, and you have a blessed day. Please have a seat in that third chair on the wall. Deja Fairman. Miss, let's see. Miss Fairman, would you please raise your right hand? Swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Okay, Miss Fairman, you may put your hand down. Let's see. Susan. This one was an add-on, right? Your full name is Deja Xavier Nicole Fairman? Okay. Now, Ms. Fairman, I have before me two documents. First document is titled Judge's Explanation of Rights of Defendants Without Attorney. Do you recognize this document? Second document is titled Jefferson County Affidavit of Indians. You recognize this document? And on page 2 of this second document, is this your signature on the line that's titled Defendant's Signature?
Yes, sir.
The first document, there's a signature at the bottom that's titled Defendant. Is this your signature?
Yes, sir.
And are these your initials on the line that state you'd like to apply for a court-appointed attorney? Now, Ms. Fairman, before you sign and initial these documents, did you read the documents? Do you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Ms. Fairman, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney John Macy. Attorney Macy will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in that third chair on the wall.
Thank you.
You're welcome. There you go. Okay. This is cause number 25CCCR 2896. Case is filed in the state of Texas versus Devin Jamal Hardy. Mr. Hardy, is that your full name? Mr. Hardy, would you please raise your right hand? Mr. Hardy, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Hardy, you may put your hand down. How are you doing, Mr. Hardy? I'm doing fine, thanks for asking. Now, Mr. Hardy, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Or are these your initials on the line that state you would like to apply for a court-appointed attorney?
Yes, sir.
On the next document that is titled Jefferson County Affidavit of Indigence, do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Now, Mr. Hardy, before you signed and initialed all of these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, now, Mr. Hardy, based on the answers that you provide, I don't think that you qualify for a court-appointed attorney. Now, let me ask you this. Let me get off of this here. Mr. Hardy,
Yes, sir.
your case is gonna be reset to give you an opportunity to hire your own attorney. Our court coordinators reset your case. Once your case is reset, you'll be free to go and you have a blessed day. Please have a seat in that second chair on the wall. Now, Ms. Fairman, would you please come back up? How are you doing, Ms. Fairman? I'm doing fine. Now, Ms. Fairman, you came up here earlier, and how old are you, Ms. Fairman? 28. Guess what? I used to be 28, 365 days. I was 28. Okay? And and I know at 28 you have friends. These days you call your friends, they call them your BFF or your ride or die. That's people that you figure will be with you when you're down and out. Or when you fall down, they'll be there to pick you up. But in my day, we used to call them our ace boom coon. Okay. And but on days like today, when you're down, you need somebody to pick you up. Those people that you call your ride or die is not here, or your BFF is not here. You know why? Because they had something else better to do than to be down here with you in court. However, there is somebody that is here with you. I noticed that there's a young lady back there, your grandmother. Okay, you know what? You look like her. I can see the resemblance. But there was nothing else in this world to stop her from being here today. Okay? You know why? Because she loves you. Now, let me tell you this. Everybody's not your friend. Everybody's not your partner. But when that lady says she got you, she got you. And, this is not the best day of her life to see you here before a judge. You might even think, my life is in shambles. I'm in a storm. But just remember this. When you're walking through a storm, hold your head high. Don't be afraid of the dark. At the end of the storm, there's a golden sky and a sweet silver song of the Lord. Walk on through the wind, walk on through the rain, though your dreams be tossed and blown. Walk on with hope in your heart, and you'll never walk alone. There's one thing about hope. Hope floats. And so when you're drowning in the sea of confusion, you can't get things right, just hold on to hope, because hope floats. And I said that to say this. Anything that you want to accomplish in life, you still can accomplish those things. Okay? Some people might look at this as a stumbling block, but you could look at it as a stepping stone. And people use stepping stones to reach higher heights. So you can reach whatever goal that you want to reach, okay? So you can just put this behind you and just continue to hold on to God's unchanging hands, okay? And I tell people this all the time. We've all sinned and fallen short of the glory of God. And we serve a God that is a God of many chances, not just a second chance, because if it was just a second chance, my second chance was over a long time ago. Okay. But you'll be all right. Now, Grandma, just hang in there with her. Hang on, don't hang up. Okay, she'll be all right. All right, so keep your head above water. Okay, and you have a blessed day. Okay, God bless you.
Thank you.
So we have some visitors from the Virginia Chamber of Commerce, is that correct? Okay, thanks for coming down here today. My name is Judge Terrence L. Holmes. I'm the presiding judge here in County Court at Law Number 2 of Jefferson County, Texas. And we'd like to welcome you being here on this morning. I tell young people this all the time. When you go to a courtroom, you can go to a courtroom in any state in the United States. Even though they look different, they are basically laid out the same way. And I'll explain that to you. In every courtroom, you'll see somebody sitting here. We call them the judge. This particular area is called the bench. The judge sits on the bench. You'll see a chair with a microphone in front of it. Normally, that chair is what we call the witness stand. And then you'll see an area where you see at least 12 chairs. We call that the jury box. And you'll see some tables in front of that wall. The two tables we call them counsel's tables. One side is for the state and the other side is for the defense. Now, if it's a civil case, it will be the plaintiff, the person who is bringing the lawsuit, or the defense, the person who is defending the lawsuit. But in criminal case, you have the state and the defense. That area that you're sitting in, we call that the peanut gallery. Everywhere you go, they call it's the peanut gallery. But it doesn't mean you can bring peanuts in here and eat, because this is not the Texas Roadhouse. Now, that wall that separates the gallery from the area where you see those tables, that wall is called a bar. Okay? Now, when individuals go to law school, once they finish college, they go to law school. And then once they finish law school, they have to take a test. The test is called the bar exam. Okay? So if you pass the bar exam, then you're allowed to come past the bar. If you have not passed the bar exam, or if you're not a lawyer, you're not allowed to come past the bar unless you're given permission to come past the bar by the court, by the judge or the bailiff. Okay? So, like I said, in every courtroom, it's laid out basically the same. You have a gallery, the bar, the counsel's tables, jury box, witness stand, and you have the bench. And also the area that's to my immediate left, this is where we have our court reporter. The court reporter is the person who types down everything that's being said. And to my right, we have our court coordinators. They're the individuals who are managing the schedules and doing the paperwork that we need to proceed in the case. Now, this morning, we have what is called an arraignment. And what the arraignment is just an opportunity for individuals who have been charged with cases to find out, what they've been charged with, what the punishment range is for that charge. And we also tell them what their rights and what their options are concerning their case. And so on today, individuals could either, first of all, they have a right to have an attorney. They can either hire an attorney, they can see if they qualify, they can ask for a court-appointed attorney. And if they qualify for a court-appointed attorney, we will appoint a court-appointed attorney, or they may represent themselves. And then when we have people that represent themselves, we say that they are pro se. Okay? Ms. Mosby. The Jefferson County Court at Law number 2 is back in session. The court is in session in cause number 25 CCCR 2938. Case and style of the state of Texas versus Caleb Tavon Franklin. To Franklin, is that your full name? Franklin, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Franklin, you may put your hand down. How are you doing, Mr. Franklin? I'm doing fine, thanks for asking. Now, Mr. Franklin, I have before me 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And is this your signature on the line that's titled Defendant? And are these your initials on the line that state that you would like to waive your right to an attorney and represent yourself? I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document? Is this your signature on the line that's titled Defendant? Now, Mr. Franklin, before you signed and initialed these documents, did you read the documents? Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Okay, now, Mr. Franklin, I need to read to you, I need to go over what we call a Ferretta warning. This is from the case of Ferretta versus California. Can be found in 422 United States 806. And need to ask you a couple of questions before we go any further. Have you ever studied law? Have you ever represented yourself in a criminal action? Do you understand the charges against you? Yeah, okay. Are you aware of the maximum punishment range?
Yes, sir.
Okay. Are you familiar with the exact legal elements for the charge? What has to be proven?
Yes, sir. Intent, knowing intent.
Well, you have the information. It's more than just those 2. Okay. Do you realize that if you represent yourself, you're totally on your own? And that as a judge, I cannot tell you how you should try your case or even advise you as to how to try your case. I cannot help you in any way. Do you understand that? Are you familiar with the Texas rules of evidence and Texas case law? Do you realize that the Texas rules of evidence and Texas case law govern governs what evidence is admitted, and in representing yourself, you must abide by those rules. For example, how do you conduct a voir dire examination? Do you know how to conduct a voir dire examination? Okay, do you know what are the grounds for excusing a juror for cause? Do you know what is hearsay? Do you know what are some of the exceptions to hearsay? Do you know what is the proper impeachment of a witness is? Do you know when character evidence is allowed in a trial? You do? Do you know when and how to make proper objections? Do you know when and how to move for a directed verdict? Do you know how to offer evidence to protect the record for appeal?
Yes,
Do you know the proper grounds for a mistrial?
yes, sir.
Are you aware that failure to timely move for a mistrial may waive crucial mistakes made by the state or this court? Do you know how to request and object to a jury charge? Are you familiar with the Texas rules of criminal procedure? Do you realize that those rules govern the way in which a criminal action is tried in court? Okay. I must advise you that, in my opinion, you will be far better defended by a trained lawyer than you can be by yourself. I think it is unwise for you to try to represent yourself. You are not familiar with the law. You are not familiar with the courtroom procedures. You're not familiar with the rules of evidence. I would strongly urge you to try not to represent yourself. Now, in light of all the penalties that you may suffer if you are found guilty, and in light of all the difficulties of representing yourself, is it still your desire to represent yourself and to give up your right to be represented by an attorney? Okay. So at this time, now, is this decision entirely voluntarily on your part?
Yes, sir.
Okay. So at this time, the court will find that the defendant has knowingly and voluntarily waived his right to counsel. I will therefore permit him to represent himself. Now, Mr. Franklin, your case is going to be reset, meaning that you will be given another court date. The court will be resetting, and the first court date, the next court date rather, that you will have is called an announcement. And at the announcement, you announce to the court whether or not you're ready for trial, or whether or not you need some more time to get discovery, do an investigation, etc. Or if you're ready for trial, then we'll set it for trial. Now, in the meantime, you'll have an opportunity to talk to the prosecutors. You'll have an opportunity to get to have access to the discovery, to the evidence in your case. Now, you would have to set up an appointment with the district attorney's office to have access to the discovery in your case. Okay, and the prosecutor, you talked to him earlier. Obviously, well, he will not be here. There'll be another prosecutor in the case because he's going to go to another. He's being promoted, and he's going to be in another case, another court rather. Okay, so she's going to give you a reset, and before you leave, you probably need to talk to him so that they can make arrangements so that you can go to the district attorney's office to view the discovery.
Yes, sir.
Okay? Okay, just have a seat. And once you finish with everything, you'll be free to go and you have a blessed day. No, he needs to talk to them.
Oh.
Instead of just.
It's gonna be a minute. You can sit back up.
He's just talking to the last person right now. Here you go. Okay. Let's see, we got Blanchard, Fulton, and Robertson. You can let him know that we're ready. Prosecutor. You can let him know that we're ready. 25 CCCR 2564, case is style of state of Texas versus Jason Joseph Blanchard. Mr. Blanchard, is that your full name?
Yes, sir.
Mr. Blanchard, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Mr. Blanchard, you may put your hand down. How are you doing, Mr. Blanchard?
All right.
I'm doing fine. Thanks for asking. Now, Mr. Blanchard, I have before me, well, the state is represented in this case by attorney Andrew Huber. Mr. Huber, how are you doing?
Doing well, Judge, thank you.
You're welcome. Mr. Blanchard, before we go any further, you have a right to have a court reporter to type down everything that's being said. And you also have the right to waive or give up your right to have a court reporter. You waive or give up the right to have a court reporter?
Yeah.
Okay, now, Mr. Blanchard, I have before me on my computer a document that is titled Information. This information alleges that you, Jason Joseph Blanchard, on or about November 11th of 2024, while you were operating a motor vehicle in a public place in Jefferson County, Texas, that you committed the Class A misdemeanor offense of driving while intoxicated with an alcohol concentration level of 0.15 or more. Mr. Blanchard, do you understand what you have been charged with?
Yes, sir.
And to this charge, Mr. Blanchard, how do you plead? Guilty, not guilty, or no contest?
Yeah.
Are you pleading guilty freely and voluntarily?
No.
And are you pleading guilty because you are guilty?
Yeah.
Mr. Blanchard, I also have before me on this tablet a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yeah.
On page 2 of this same document, there's 2 sets of initials. First set of initials is on the line next to boxes checked guilty. You place your initials on this document,
Yes.
in this location. The second set of initials is on the line next to a statement that reads, I do not request discovery. I waive my right to discover in this case and choose to enter a plea of guilty and no contest. You place your initials in this second location. On page 3 of this same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
On the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Right.
And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And is this your signature on the line that's titled Defendant? And are these your initials on the line that state you like to waive your right to attorney and represent yourself? I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document? And is this your signature on the line that's titled Defendant? Now, Mr. Blanchard, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Blanchard, are you a citizen of the United States?
Yeah.
State, would you like to offer State's Exhibit Number 1?
Yes, Your Honor.
Mr. Blanchard, the state is offering State's Exhibit Number 1 to be used as evidence against you in your case. State's Exhibit Number 1 is the first document that I showed you on this tablet. This is the same document that have your initials in these 2 locations, and it has your signature on page 3. Is it all right for the state to use this document as evidence in your case? Okay. No objections. State's Exhibit Number 1 would be admitted. Mr. Blanchard, is there any evidence that you are currently mentally incompetent to stand trial? Okay, Mr. Blanchard, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
What is that agreement?
The agreement in this case is to 180 days probate over 18 months with a $500 fine, 40 hours community service, the installation and maintaining of an airlock device, and DWI or conditions of probation.
Okay. Now, Mr. Blanchard, the state is offering that you serve 180 days in the Jefferson County Jail, but you will not be required to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 18 months. During the 18-month probationary period, let's see. Here's a fine. What's the court cost?
377.
Okay. Mr. Blanchard, the state is offering that you serve 180 days in Jefferson County Jail, but you will not be required to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 18 months. During the 18-month probationary period, you'll be required to pay a fine of $500 plus court costs of $377. You will also be required to pay a probation fee of $60 a month, urinalysis fee of $15 a month, reimbursement fee of $15, and you'll be required to pay Jefferson County DWI conviction fine fee of $100. Your total monthly installments, that is, the total amount that you will be required to pay each month, in this case, is $138 a month. Are you able to pay $138 each month?
Yes.
You'll also be required to pay Jefferson County DWI education and initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional fee of $50. Now, you will also be, is there any community? Yeah. Is
Yes,
there?
Your Honor, 40 hours.
Oh, it's 40, okay. You'll also be required to perform 40 hours of community service, have an interlock device installed in any vehicle that you own or operate, attend and complete a DW education class, and have an alcohol assessment as well as adhering to the other standard terms and conditions of this probation. Mr. Blanchard, do you understand the state's offer?
Yeah.
And do you think that the state's offer in your case is fair and just?
Yes.
And do you accept the state's offer?
Yes, sir.
Okay, Mr. Blanchard, please have a seat in, do you have his paperwork? Okay, please have a seat in that first chair and wait for your name to be called.
We're doing that, he said something about transfer and like community service, that'll be done in probation.
Yeah, you got to talk to the probation department about that.
Yeah.
Okay. Who was that? Michael Fulton? Michael Fulton? Okay. Mr. Fulton, your full name is Michael Fulton? Mr. Fulton, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Fulton, you may put your hand down. How are you doing, Mr. Fulton? I'm doing fine. Thanks for asking. Where's his waivers?
Right here on the second.
Okay. Now, Mr. Fulton, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? You have to speak up.
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
Are these your initials on the line that state you like to apply for a court-appointed attorney?
Those were crossed out.
Oh, he's crossed that one, okay. Now, are these your initials on the line that state you would like to waive your right to an attorney and represent yourself?
Sir.
Okay, let me erase that one. And on the next document is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Is this your signature on the line that's titled defendant? Okay. Now, Mr. Fulton. Let's see. And cause number 25 CCCR 1364. I have before me on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, Mr. Fulton, it alleges that you, Michael Fulton, on or about September 8th of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of possession of marijuana. Mr. Fulton, do you understand what you have been charged with? To this charge, Mr. Fulton, how do you plead? Guilty, not guilty, or no contest?
Yes.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you are guilty?
Yes, sir.
Mr. Fulton, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishments. This document also is labeled as State's Exhibit Number 1. Do you recognize this document? You do? Okay, on page 2 of this same document, there are two sets of initials, MJF.
Yeah, it's my.
And did you place your initials on the first line that where the box is checked guilty?
Yeah.
Now, the second set of initials are on the line next to a statement that reads, I do not request discovery. I waive my right to discovery in this case and choose to enter a plea of guilty and no contest. Did you place your initials in the second location as well? On page 3 of the same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document? And is this your signature on the line that's titled Defendant? At the top of this document, there are two boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes.
Now, Mr. Fulton, before we go any further, you have a right to have a court reporter to type down everything that's being said, and you also have a right to waive or give up your right to have a court reporter. You waive or give up your right to have a court reporter? You want a court reporter? Okay.
Oh,
Pause. Oh, okay. We're just gonna call this, okay. Okay, now, Mr. Fulton, before you signed and initialed all of these documents that I just showed you,
Yeah,
did you read the documents?
yes,
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Fulton, are you a citizen of the United States?
yes, sir.
Silver States one.
Mr. Fulton, the state is offering State's Exhibit number 1 to be used as evidence against you in your case. State's Exhibit number 1 is the first document that I showed you on this tablet. It is the same document that have your initials in these two locations on page 2, and it has your signature on page 3. Is it all right for the state to use this document as evidence in your case? Okay, no objection. State's Exhibit number 1 will be admitted. Now, Mr. Fulton, is there any evidence that you are currently mentally incompetent to stand trial? Okay, Mr. Fulton, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
The agreement on this case is to 6 months deferred probation with a $150 fine, 24 hours community service. Additionally, defendant's companion case, the UCW, will be dismissed for forfeiture to the Beaumont Police Department.
Say 6 months deferred.
Yes, Your Honor.
That's $150 fine. What's the court cost?
277.
277. Okay. Mr. Fulton, the state is offering that you serve 6 months deferred adjudicated probation. During the 6-month probationary period, you will be required to pay a fine. You have to pay that $100 fee to okay, hold on a minute. Need to add something else in here. Okay, now, Mr. Fulton, the state is offering that you serve 6 months deferred adjudicated probation. During the 6-month probationary period, you'll be required to pay a fine of $150 plus court costs of $277. You'll be required to pay a probation fee of $60 a month, your analysis fee of $15 a month, reimbursement fee of $15, and you're also required to pay $100 to Jefferson County Crime Lab. Your total monthly installments, that is the total amount that you will be required to pay each month, is $198 a month. Will you be able to pay the $198 each month? Okay. You will also be required to perform 24 hours of community service, and the state will be dismissing the companion case, cause number 25 CCCR 1358 for forfeiture of a weapon to the Beaumont Police Department. In that case, I have before me a document that is titled Motion to Forfeit. Do you recognize this motion?
Yes,
And is this your signature on the line that's titled defendant?
yes, sir.
Before you sign this document, did you read the document?
Yes.
Did you understand what you read? Is everything in this document true and correct to the best of your knowledge? Okay, Mr. Fulton, the court is signing an order granting the forfeiture of this weapon to the Beaumont Police Department. Now, Mr. Fulton, do you understand the state's offer?
Yes.
And do you think that the state's offer in this case is fair and just? And do you accept the state's offer? Mr. Fulton, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Fulton, if you successfully complete this probationary period, this case will be dismissed. It would not result in a conviction on your record, and you may qualify for a non-disclosure, or your record will be sealed to the general public. You can talk to an attorney about the non-disclosure. Now, Mr. Fulton, you're gonna have a seat in that first chair, wait for your name to be called. You're gonna follow the directions of the bailiff. Once you finish following her directions, you'll be free to go, and you have a blessed day. A forfeiture is not where?
It doesn't say that.
They dismiss. You're talking about on the plea form.
Okay. Thank you, Judge.
Okay, you're welcome. Sign his dismissal too. Ronald Wayne Robertson.
Right there.
Mr. Robertson, your full name is Ronald Wayne Robertson.
Yes, sir.
Mr. Robertson, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Robertson, you may put your hand down. How are you doing, Mr. Robertson? I'm doing fine, thanks for asking. Now, Mr. Robertson, I have before me document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line stating that you'd like to waive your right to an attorney and represent yourself?
Yeah.
I also have another document that is titled Waiver of Counsel for Purposes of entering guilty plea or proceeding to trial. Do you recognize this document? And is this your signature on the line that's titled defendant? Now, Mr. Robinson, I also have before me on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Ronald Wayne Robertson, on or about July 25th of 2025, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of driving while intoxicated, which allegedly occurred on or about, as I mentioned to you, allegedly occurred on or about July 25th of 2025 while you are operating a motor vehicle in a public place in Jefferson County, Texas. Mr. Robertson, do you understand what you've been charged with?
Yes, sir.
And to this charge, how did you plead? Guilty, not guilty, or no contest? No contest. Now, are you pleading no contest freely and voluntarily?
Yes.
And are you pleading no contest because you do not wish to fight or contest the charges? Okay. Now, Mr. Robertson, I also have before me a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit Number 1. Do you recognize this document? On page 2 of this same document, there are 2 sets of initials. The initials are R or R. Did you place your initials on the first line that is titled guilty? The second set of initials is on a line that states, I do not request discovery. I waive my right to discovery in this case and choose to enter a plea of guilty and no contest. Did you place your initials on this second location? On page 3 of this same document, there's a signature above the line that's titled defendant. Is this your signature? On the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document? And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? And the second box check states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? Okay. Now, Mr. Robertson, before you sign and initialed all of the documents that I just showed you, did you read the documents?
No.
Did you understand what you read?
No.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay. Now, Mr. Robinson, are you a citizen of the United States?
Sanford State's 1.
Okay, Mr. Robinson, the state is offering State's Exhibit Number 1 to be used as evidence against you in this case. State's Exhibit Number 1 is this first document that I showed you on the tablet. It is the same document that has your initials in these 2 locations, and it has your signature on page 3. Is it all right for the state to use this document as evidence in your case? Okay, no objection. State's Exhibit Number 1 will be admitted. Now, Mr. Robinson, is there any evidence that you are currently mentally incompetent to stand trial? Okay. Now, Mr. Robinson, I will accept your plea of no contest. Hold on a minute. Yeah. I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
The agreement in this case is to 9 months deferred probation
9 months deferred.
with a $300 fine and waiver of community service hours, the installation of a tape and airlock device, and DWI standard conditions of probation.
Okay, let's see. What's the court cost?
492.
$392. $60 times 9. equal 540. Let's see, 540. 15 times 9. $15 plus. Or she's not his attorney.
No, that's his daughter.
Okay. Let me see this. It's 500 plus. Uh-oh, let me do this here. Now, before we go any further, now the young lady in the back, that's your daughter?
Yes, sir. I just know what some of the ad said that that's my daughter, she's helping me out now.
Okay, now, she had requested, now ma'am, we do this here. Have it a step right here. Okay, so, State, could you repeat the plea bargain agreement?
Yes, Your Honor. 9 months deferred adjudication with a $300 fine. The waiver of community service hours. Interlock, the maintaining and of an interlock device and DWI standard conditions of probation.
Okay. Okay, now, Mr. Robertson, the state is offering that you serve 9 months deferred adjudicated probation. During the 9-month probationary period, you'll be required to pay a fine of $300 plus court costs of $392 plus court costs of $392. You'll also be required to pay a DWI conviction fine fee of $100, a probation fee of $60 a month, your analysis fee of $15 a month, reimbursement fee of $15. You're also required to pay Jefferson County DWI education and industry evaluation fee of $125 on the day of the plea. And you'll, if you cannot, well, if there's an additional fee, you will have to pay an additional $50. Now, your total monthly installments for this case is $185 a month. Are you able to pay the $185 a month?
Yes, sir.
Okay. And also, okay, let's see. You're also required to adhere to the other standard terms and conditions of this probation.
Sir.
You're also required to adhere or follow the other standard terms and conditions of this probation. Now, Mr. Robertson, do you understand the state's offer?
Yes, yes, sir.
And do you think the state's offer in your case is fair and just?
Do I think it's what?
Fair and just?
Yes, sir.
Do you accept the state's offer?
Mo.
Yes, sir.
Okay, Mr. Robinson, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Robinson, if you successfully complete this probationary period, this case will be dismissed. It will not result in a conviction on your record, and you may qualify for non-disclosure, whereby the record will be sealed to the general public. Okay, you can talk to an attorney about that. Okay, just have a seat. I'll follow the plea bargain agreement. Just have a seat in that first chair and wait for your name to be called. There you go.
Down.
Carl Edward Branch. Oh. That gentleman was supposed to talk to, okay. Mr. Branch, your full name is Carl Edward Branch?
Yes.
How are you doing, Mr. Branch?
Great.
Mr. Branch, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Branch, you may put your hand down. How are you doing, Mr. Branch?
I'm fine about the
I'm doing fine, thanks for asking. Mr. Branch, I have before me a document that is titled information. This information, you have this paperwork?
Yes, Your Honor.
Well, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes.
Is this your signature on the line that's titled Defendants? Or are these your initials on the line that state you like to waive your right to an attorney and represent yourself? And I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And Mr. Branch, is this your signature on the line that's titled
Yes.
Defendant? Now, Mr. Branch, I also have before me a document on my computer that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Carl Edward Branch, on or about August 2nd of 2025, while you were in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the Class A misdemeanor offense of driving while intoxicated with an alcohol concentration level of 0.15 or more. Mr. Branch, do you understand what you have been charged with? To this charge, Mr. Branch, how do you plead? Guilty, not guilty, or no contest? Are you pleading no contest freely and voluntarily?
Yes.
And are you pleading no contest because you do not wish to fight or contest the charges? Mr. Branch, I also have before me on my computer a document that is titled Misdemeanor Plea Admonishment. It's also labeled as State's Exhibit Number 1. Do you recognize this document? On page 2 of this same document, there are 2 sets of initials, CB. First set is on the line next to the box that's checked no contest. You place your initials on this document. Second set of initials is next to a statement that reads, I do not request discovery. I waive my right to discovery in this case and choose to enter a plea of guilty or no contest. Mr. Branch, did you also place your initials in that second location? I also have before me a document that is titled, well, on page 3 of this document, there's a signature above the line that's titled Defendant. Is this your signature?
Yes.
On the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes.
And is this your signature on the line that's titled Defendant?
Yes.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have before me a document that okay, now before you sign and initial all of these documents, did your attorney go over these documents? Well, did you go over these documents?
Yes.
And did you understand what you read?
Yes.
And then is everything in these documents true and correct to the best of your knowledge?
Yes.
Mr. Branch, are you a citizen of the United States?
Yes.
046-1.
Now, Mr. Branch, state is offering State's Exhibit Number 1 to be used as evidence in your case. State's Exhibit Number 1 is this first document that I showed you on this tablet. It is also on the second page, it have your initials in these 2 locations, and it has your signature on page 3. Is it all right for the state to use this document as evidence in your case? No objection. State's Exhibit Number 1 will be admitted. Mr. Branch, is there any evidence that you are currently mentally incompetent to stand trial? None? Okay, Mr. Branch, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargaining agreement?
We do, Your Honor.
And what is the agreement?
The agreement in this case leads to 90 days probated over 1 year with a $500 fine, 4 years community service, the installation maintained an interlock device, and DWA standard conditions of probation.
You said 4 years ago.
4 years community service?
40 hours.
Yes.
Oh, okay.
What's the court cost?
Full cost of that.
That's the standard court cost. It'll give you a breakdown in the judgment why the court cost is what it is. Okay. Mr. Branch, the state is offering that you pay a fine of $500 plus court costs of $392. You're also required to pay a probation fee of $60 a month, urinalysis fee of $15 a month, reimbursement fee of $15. You'll be required to pay DWI conviction fine fee of $100. Your total monthly installments, that is the total amount that you'll be required to pay each month, is $173 a month. Are you able to pay the $173 a month?
Something, not maybe.
Okay, we need an affidavit.
We don't have one.
So you have to fill out an affidavit. Having to fill out an affidavit. Yeah. Just have a seat in at that table. We'll call you back up. So you stated that you're able to pay $173 a month. Is that correct?
Just keep it all off at one time.
Yeah. Yeah, that's not a problem. Now, also, you'll be required to perform 40 hours of community service, install an interlock device on any vehicle that you own or operate, attend and complete DWI education class, have an alcohol assessment, and adhere to the other standard terms and conditions of probation. Mr. Branch, do you understand the state's offer?
Yes.
Do you think the state's offer in your case is fair and just?
Yeah.
Do you accept the state's offer?
Yes.
Mr. Branch, I'll follow the plea bargaining agreement that you have entered into with the state. Mr. Branch, you're gonna have a seat and wait for your name to be called. You're gonna follow the directions of the bailiff. Once you finish following the directions of the bailiff, you'll be free to go and you have a blessed day. Thank you. Any witness? What is this? I see Miss Jones. Okay, give me hold on a minute. Let me see, wait a Jones. Oh, How you pronounce your first name? Danae,
Yes.
okay.
I have a hyphen in between,
You have a hyphen,
in between the N.
oh, okay, because it's not like that on here, okay. Danae, okay.
What's your name?
Branch, yeah, hold on a minute. Okay. Jefferson County Court at Law number 2 is back in session. Court is in session and calls number 25 CCCR 1972. Case is style the state of Texas versus Saul R. Gaona. Saul Gaona was scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court's bailiff called the name of Saul Gaona at the courthouse door. He did not appear. He did not answer. He has not appeared in this court. Time now is 12:59 p.m. on today's date of February 10th, 2026. Ms. Bailiff, would you please call the name of Saul Gaona?
Saul the owner. Saul the owner. The response, Your Honor.
Okay. Saul Gaona was scheduled to be in court. He did not appear in court at 9 a.m. on today's date. Court has given him a reasonable time to appear in court. He has not appeared. State, you have a motion?
Same as for bond forfeiture.
That motion will be granted. Saul Gaona's bond will be forfeited. Warrant should be issued for his arrest and cause number 25 CCCR 1972. Next case is cause number 25 CCCR 2412. Case is styled the state of Texas versus Clayton Garlow. Clayton Garlow was scheduled to be in court this morning at 9 a.m. Hold off on this.
Yeah.
Okay. 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 Well, this will conclude.
And Your Honor, Ms. Jones' case will be a dismissal.
That'll be a dismissal.
Yes, sir.
Okay. Jones is gonna be a dismissal. There you go. Okay. Okay, hold on a minute. He's sitting at dismissal on Jones. Okay, but hold on. Jefferson County Court at Law number 2 is back in session. Now the court is concluded with the arraignment docket on today's date of February 10th, 2026, in County Court at Law number 2, Jefferson County, Texas. Judge Terrence L. Holmes presiding. Everyone, please have a blessed day. Prosecutors, you are excused.
Thank you, Judge.